This is Constitutional Law Part 4, beginning with the Takings Clause. This applies to the federal government through the 5th and the states through the 14th. This is the check on the power of eminent domain. Property may not be taken for public use without just compensation. Here the plaintiff must have a property interest. That property interest may be real or by contract or even intellectual property. Where there is a seizure, the plaintiff's primary challenge is just compensation. If the seizure is for public use and the government transfers a property to another party, the plaintiff can challenge on the basis of public use, so not just compensation alone, but also public use. Here, the taking need only be rationally related to a conceivable public purpose. This is very deferential. Under the Takings Clause, an exaction is where the local government gets the developer to set aside a portion of a development land for park in exchange for issuing construction permits. They're exacting something from the developer. That's why it's called an exaction. This is okay. It must have an essential nexus between legitimate state interest and conditions imposed on the property owner, and there's a rough proportionality between the burden imposed and the impact on development. Just compensation under the Takings Clause, it's generally the fair market value. However, where the property is worthless to the owner but valuable to the government can take it without compensation. If only a portion is taken, the owner must be compensated for diminution in value of the remainder. And if the government returns the property, the government must pay the owner for the time that the property was seized. Moving on to ex post facto laws and prohibited legislation. This is in Article 1, Section 9 and 10. The government cannot criminalize an act, not a crime, when the act was originally committed, or after an act has been committed, authorize a more severe penalty for that act, or deprive a defendant of an offense, or decrease the state's burden of proof. Again, that's Article 1, Section 9 and 10. Obviously, it's Article 1, it's prohibited legislation. Article 1 is legislative. Article 2 is executory, and Article 3 is judiciary. Generally, the ex post facto laws and prohibited legislation is confined to criminal and or penal laws. However, it does include civil laws whose punitive effect clearly overrides its civil purpose. Moving on to freedom of religion and the establishment of religion, the standard of review. Government cannot establish a religion. This is under the First Amendment for the federal government and the states for the 14th Amendment. This is where there is preference for one religion over another and or for religion over non-religion. While the government can generally not establish a religion, anything that it does in regards to religion may be valid if it is done with a secular purpose. Its primary effect neither advances nor inhibits religion, and there is no excessive government entanglement, and that's the Lemon test. In regards freedom of religion in regards to financial aid, where there is aid to schools, and this includes to secular and parochial schools, if it is available to all schools, it's okay. So you can give money to parochial schools as long as it is also given to all other schools. In the context of vouchers, these are okay if it's available for religious and non-religious schools. In regards to college and hospitals, aid is okay if it's used for non-religious purposes. So if you have a religious hospital and they get aid from the government, that's okay as long as they use it for a non-religious purpose. So you can't build a chapel. You can't use that money to build a chapel in the hospital, but they may use it to build a daycare. Tax exempt status of churches, that's okay. And it's similar to charitable organizations exemption. School activities under the Freedom of Religion and Establishment Clause, these are generally held invalid. School activities related to religion are generally held invalid. and these include such things as voluntary and or involuntary prayer, obviously involuntary, Bible readings, meditation even, 10 Commandments, and prohibitions on evolution, on teaching evolution. Now, if student organizations use facilities while the school is not in session, then the school must allow religious organizations to use those same facilities outside of the school session. Looking at religious displays and the establishment of religion, look to whether there is a predominantly religious purpose. If they include a secular moral message or display historical and or social meaning, then those religious displays or displays may be upheld. Predominantly religious purpose, more likely not upheld. Secular moral message displays historical social meaning, may be upheld. Also consider in that context where they are including only one religious symbol or symbols, or multiple, or the symbols of multiple religions. Looking at free exercise of religion, this goes to religious beliefs. This cannot be infringed upon. You cannot prescribe religious beliefs. However, you can prescribe religious conduct. Religious conduct can be infringed upon. So a law, and examples would be law targeting religious conduct, such as banning all animal sacrifice except for food. This is going to receive strict scrutiny and more than likely be struck down. However, a neutral law of general applicability, such as criminalizing peyote, generally, even though it is used in religious ceremonies, will receive rational basis review and will generally be upheld. And that completes part 4 of constitutional law.